Good afternoon, everyone. On behalf of New York MBA's President Mike Culver, our Executive Director Joe Culver, and the entire New York MBA Board, thank you for joining today's webinar. My name is Elizabeth Shaney, and I'm proud to serve on New York MBA's Education Committee alongside my co-chair, Phil Kennedy. Before we dive into today's program, I'd like to quickly highlight some exciting educational opportunities we have coming up this month. We have our Affordable Friday series on June 20th, discussing CRA and MLO's role in outreach. And we have Jackie G with her TED on Tech series on June 25th with Steve Baseless from Optimal Blue discussing various AI components. Now, before we begin, a few housekeeping items. First, if you experience any technical issues during the webinar, please notify us using the chat function. All participant lines are muted except for our panelists. We encourage you to ask questions throughout the session using the chat and/or QA functions. After the webinar, we'll share the presentation slides and relevant resources with you. Stay connected with the New York MBA. You can find us on LinkedIn at newyorkmba.org and our YouTube channel at New York Mortgage Bankers Association, where we post webinar recordings such as this one. Lastly, I urge all mortgage professionals to consider joining the Mortgage Action Alliance. It's free, easy, and a fantastic way to stay informed about legislative issues that affect our industry. And now I'll turn the webinar over to Jody Gaines, who is today's session moderator. Jody, take it away.
Thank you, Liz. So good afternoon, everyone. I'm Jody Gaines, CEO of Claims Recovery Financial Services and G7 Service Group, and also, very important, a New York MBA member. Today's session is sponsored by G7 Service Group. So just a little shout out to them. G7 Service Group is a founder-led property preservation, renovation, and repair company built by mortgage servicing executives that have combined over 100 years in the mortgage space industry. So as we get started for today's webinar, just a couple things. So today we are going to be focused on legislative and judicial developments shaping the industry starting right here in New York. And just a little bit of a background about some of the work that the New York MBA is doing is that, on a daily, weekly, monthly basis, we are partnering with our lobbyist, Brown Weinrob, and we are monitoring all legislative updates and impacts that impact our members and our industry. And we're heavily focused on doing this so that we can weigh in on legislation. We can either support it, we can oppose it where we need to, and we can offer suggestions on how to amend it. And we're always doing this. The eyes and the ears of the industry, looking to protect our members and certainly protect the industry. So a little bit of a background around the hard work that we're doing, advocating every single day on your behalf. So we're going to go ahead and do a quick introduction of our speakers, and then we'll go ahead and get started. So not in order of importance, because all of our panelists are very, very important. And I will also add they're all members of the New York MBA, and they're very helpful in all the hard work that we're doing. So I'm going to kick it off with Adam Swanson, who is a partner of McCarter & English and has extensive experience in the industry. Adam is a consumer finance and real estate litigator with over 21 years of experience in the industry. Next up, we have Adela Martinez, who's the VP of Default Management at Planet Home Lending. And gosh, Adela, 37 plus years in the industry. So we're really, really close there, connected on how much experience we have. And I know Adela has a broad breadth of experience in the industry, reaching well beyond the default space. And then we have Adam Vargas, who is with Friedman and Vartello, and Adam is I apologize, a New York consumer financial services and real estate litigation attorney with I think, gosh, Adam, 20 plus years of experience. So, and then we have a contributor who is not here, but we would be remiss if we did not give him a shout out because he helped us with the presentation in a bunch of the legislation, and he's just an absolute asset to the New York MBA, and that is Chip Nolan, who is a VP of Operations and Execution from Braun Inc. So with that, all that being said, We have a little agenda here just so everybody knows how this is going to go. We're going to start out with FAPA and a little background about FAPA, and then we'll roll into the rest. And to get us kick-started will be Adam Swanson. So Adam?
Thank you, Jody. Good afternoon, everyone. And when Jody said I had 21 years experience, my eyes went because I've only been practicing law since '08, but Jody, you're right. In '04, I was an intern at First American Title Insurance. So I guess I have been for 21 years. That doesn't seem possible. Okay. All right. Good afternoon, everyone. One thing when I was giving this presentation in San Diego at the Mortgage Bankers Association's LERC conference, that dawned on me was many people in the audience may not know what FAPA even is. And we take for granted and we just talk about FAPA. And I asked the audience if anybody didn't know, and one person raised their hand. So for that one person who's among our 51 participants, this slide is dedicated to you. So on December 30th of 2022, FAPA was enacted. FAPA stands for the Foreclosure Abuse Prevention Act. It was an act of the legislature which made key changes to how a mortgage is accelerated. An acceleration is very meaningful to the statute of limitations and very important. The most important changes that were made by the Foreclosure Abuse Prevention Act was how and when a mortgagee, a mortgage owner, may revoke the acceleration in a mortgage. And the reason that matters is because once the mortgage is accelerated, you got 6 years to foreclose it. And if you don't, you lose the entire asset. Two examples of what the changes were, and these are two of the major examples, although there were many other changes. One example is that there was a determination by the New York Court of Appeals that when a lawsuit, a foreclosure suit, was voluntarily discontinued, that revoked the acceleration. That's no longer true under FAPA. A voluntary discontinuance will not revoke the acceleration of the loan. The second example is that whether or not there's a, quote, valid acceleration. So how that came to be was where a plaintiff commenced a foreclosure suit and they did not hold the note, or they were not the owner of the mortgage, and they therefore did not validly accelerate it. The legislature said, no, we're not going to allow that to happen anymore. So the net effect is that once you as a mortgage owner or mortgage servicer have accelerated a loan, now it is very difficult to revoke that acceleration. And you must take very specific action to revoke that acceleration. And the borrower is going to have to agree to it because all that prior law went out the window. The key thing that really has created a lot of controversy in the industry is actually Section 10 of the Act, which gives these new rules retroactive application. So in other words, it's not just that if you voluntarily discontinue an action today, it does not revoke the acceleration of your loan. If you did it 5 years ago, not knowing the law was going to change, it applies then too, under the terms of the statute. That's what's created the issues in the industry. That's what we've been fighting now for the last several years. And Steve Vargas is now going to talk about what the New York Mortgage Bankers Association is doing in the U.S. Bank versus Fox case to try and change the retroactive application that FAPA purportedly allows.
Thanks, Adam. I'm going to start with an introduction on the Fox case, why this case is important, why this was a very good case to bring to the United States Supreme Court. So as a preview, before I actually get to the slideshow, a background on Fox, which involved two foreclosures. U.S. Bank versus Fox, which Adam Swanson's firm is actually handling in a petition before the Supreme Court that I'll tie into the slides, illustrates the legal quagmire associated with the indefinitely retroactive application of FAPA. In the opinion of myself and Adam and a number of industry colleagues, this retroactive activity clause violates the due process and takings clauses of the United States Constitution. So a background, Fox took out a mortgage and defaulted in 2009. In 2010, One West Bank, which was the mortgagee at the time, commenced a foreclosure action, which triggered the statute of limitations. The foreclosure action by One West was dismissed by the trial court in 2019, 3 years after the 6-year period expired, and the dismissal was affirmed by the Appellate Division First Department in 2021. U.S. Bank, the successor to One West, commenced the second foreclosure action in 2021 by relying on the Civil Practice Law and Rules 205A savings statute, a statute created by the legislature and existing for several hundred years in various forms, which told the statute of limitations period to commence a subsequent foreclosure or any type of action in the event that the first action was dismissed for on a non-merits basis or non-jurisdictional basis. So in the overwhelming number of lawsuits, the prior action is dismissed, on a technical defect, which is what happened here. And then the restart was brought by potentially a successor or the same entity. And here, US Bank, relying on this savings statute, brought the new action. Fox moved for dismissal, arguing that the savings statute didn't apply, and the trial court in New York County in Manhattan granted the motion and dismissed the complaint in early 2022. US Bank took an appeal from the dismissal, and here's where the illustration of FAPA's impact comes into play. After the appeal was fully briefed by the parties and after the appellate court heard argument in which the parties addressed pre-FAPA law, FAPA was signed into law on December 30th, 2022. As pertinent to Fox, FAPA's CPLR 205 Section C and 205-A taken together created a mortgage foreclosure specific savings statute that was far more stringent than the statute that applied to all other civil actions. On January 5th, 2023, the First Department, the Appellate Division, reversed the dismissal order, holding that the action was not time barred as it was brought within the 6 months of the dismissal of the prior foreclosure action. So in the first decision we're talking about, the January 2023 decision, we're saying that US Bank correctly restarted the case, timely did so, relying on a statute that existed in various forms, like I said, for 200 years. Neither party addressed FAPA because it was signed into law days before the appellate decision. The appellate division obviously didn't apply it as a result. So what the borrower did was, shortly after the appellate court issues a ruling on January 5th, 2023, saying US Bank properly relied on this statute, borrower files a motion to re-argue the appeal, claiming FAPA changed the law. The parties briefed the issue and addressed FAPA with various arguments. On May 4th, 2023, the appellate division First Department effectively reversed itself. They issue a ruling reversing the January 23 order, noting in relevant part, quote, FAPA provides that it shall take effect immediately and apply to all foreclosure actions in which a final judgment of foreclosure has not been enforced. Accordingly, it applies to this foreclosure action. And that's something we can get into shortly about the retroactivity clause. And then they applied a new foreclosure-specific savings statute that was created as part of FAPA, CPLR 205-A, subsection 1, to essentially nullify and void the fact that US Bank complied with the then applicable 205 parentheses A and dismissed the 2021 foreclosure as time barred. These decisions illustrate that under the old law, the action was adjudged timely by an appellate court. The plaintiff complied with then existing law. They also illustrate that based solely on the retroactivity clause in FAPA, the action was then retroactively rendered time barred subject to dismissal. So that is a prime example of what we're seeing in the litigation across the trial and appellate courts in hundreds of cases in all 4 appellate departments, from New York City upstate. And Adams Firm filed a petition on behalf of US Bank to appeal to the US Supreme Court.
And Steve, that's what I think is so great about the Fox case, is it demonstrates exactly the impact of FAPA, and we're seeing it across the industry. One client telling me 150 million of lost secondary mortgages purchased on the secondary market. Is you had a right, you asserted that right, you had an enforceable mortgage, FAPA's passed, you no longer have that right, and the mortgage is a complete loss.
Exactly. And that's why there were a number of cases that were potential candidates, just due to the negative impact that FAPA's had, potential candidates to try to bring up to the nation's highest court. But Fox was a perfect example illustrating the FAPA impact. So what the New York Mortgage Bankers Association did is they took the lead to file an amicus curiae brief. So the New York Mortgage Bankers Association along with several trade organizations whose members include mortgage investors, lenders, and servicers, will be filing an amicus curiae brief in mid-June, over the next 2 to 3 weeks, in support of U.S. Bank's petition for writ to the Supreme Court of the United States. So what that means is this organization is going to be filing a brief in the U.S. Supreme Court, not just in the state courts, not just in a federal appellate court, in the highest court in the land. Freeman Bartolo represents the NYMBA, as well as at least one other organization, ISLE. There are 3 other organizations that may potentially join on to the joint brief, which is currently jointly going to be filed by NYMBA and ISLE. We'll know by the end of the week whether we'll have the 3 other organizations participating. And the goal is actually to file the brief next week. Fox, this is more towards the slideshow. Fox is the first challenge to the retroactive application of FAPA presented to the Supreme Court. There have been challenges made to all of the intermediate appellate courts. There have been papers filed in the Court of Appeals, motion papers, but it has never been brought to the U.S. Supreme Court. And what we're doing is, and what U.S. Bank through Adams Firm is doing is, challenging the retroactivity clause as violative of the United States Constitution's due process and takings clauses. There were several challenges to FAPA retroactivity in the Federal Court of Appeals on these bases, as well as in the New York Court of Appeals. There are actually 2 cases. The New York Court of Appeals, the state's highest court, agreed to hear on FAPA retroactivity issues. But the most prominent case is certainly U.S. Bank versus Fox, due to the court that the briefs are being filed in, as well as the potential for the U.S. Supreme Court to take a case and issue a ruling on the retroactive application of a New York state law. And it's potentially the most high-level litigation this organization has ever been a part of, which is why it was critical to be involved and take a lead. Really, the NYMBA was really the thought leader as far as amici are concerned. And from day one, taking a lead on this issue, advocating against the legislation going back to 2021, filing briefs, amicus briefs in other cases, and here to the highest court in the land. As far as what we're going to discuss in the brief, there are the 5 main points we're going to discuss in the brief. Important. The first point is that the Supreme Court is not, well versed in New York judicial foreclosures. The judicial foreclosure process or non-judicial foreclosure process varies dramatically across the states. Each state has their own specific requirements. Half the states roughly in the country are not even judicial foreclosure states. So it's simply, a notice and an auction sale. New York is a very arduous process that the bank has to work its way through. A lot of technical statutory requirements, changing case law. So we wanted to explain to the court how the process works, why it's complicated, why it isn't just sending a notice of default and then scheduling an auction sale. Also, articulating on behalf of the MBA, the members of the organization, how the retroactivity clause destabilized the secondary mortgage market. As far as, loans, take huge losses on loans like Adam mentioned. Discussing Supreme Court precedent in which the nation's top judges have held in the U.S. Supreme Court case law that their retroactive statutes are typically rejected by the U.S. Supreme Court, violating the due process and takings clauses of the U.S. Constitution. There's consistent case law from the Supreme Court that retroactive legislation is strongly disfavored and oftentimes rejected as unconstitutional because it's fundamentally unfair to impose new standards and burdens on parties any period after its effective date, any period prior to the effective date, and in FAPA's instance, in an indefinitely retroactive manner. And we're really highlighting it because FAPA is not only retroactive, it's an indefinitely retroactive period. And that's really distinct because there's no other statutes that anyone has identified thus far on the defense side or even on the plaintiff side where a retroactive statute that's indefinite in nature has been upheld as constitutional. We also identified some federal and state court decisions in which, particularly the federal appellate courts, issued decisions questioning the retroactivity clause as far as its validity. So those are 2 cases that are mentioned in the prior slide, East Fork Funding and Article 13 LLC. In those cases, the Second Circuit Court of Appeals, one of the highest appellate courts in the country, seemed skeptical about the retroactivity clause's enforceability. And finally, we actually suggest at least one alternative to applying FAPA amendments retroactively that will uphold the legislative intent or purported intent while avoiding unconstitutional due process and takings clause violations in litigation. So Adam's brief was filed on May 14th. The NYMBA brief through Friedman will be filed. We're aiming for the end of next week. A few other trade organizations are filing briefs through other law firms, something in the next week and a half. And then after that, it's a wait and see approach. And if the Supreme Court takes the case, this will certainly become among the most high profile New York related litigation cases arising from New York State in the country at this period of time, because to my knowledge, there are no more than maybe one case pending before the US Supreme Court regarding an issue of New York law. So this is extremely important. And although it's difficult to get the Supreme Court to accept petitions, it's an uphill battle in that sense, because the Supreme Court has discretion to entertain cases. This is extremely compelling. And the gravity of the losses is so significant in terms of the financial impact that the court has a good reason to take this case.
Thanks, Stephen. I think we're gonna move on to a couple more slides in regards to FAPA that Adam has prepared for us to help our servicers really protect their interests in making sure they're doing everything that they can to avoid losing homes to FAPA. And then after that, we're going to pause and take some Q&A before we move on. So, Adam?
Thanks, Jody. Right. So, I just want to point out, since Fox is our case, that the Supreme Court only grants about 50 motions to review cases a year. So the chances of Fox being taken are still slim to none, just based on the odds. But we certainly hope it is. And so now moving on, the thing about it is FAPA is here to stay. So this retroactivity issue, it's going to get resolved, and it's no longer going to be the issue. But what really is going to be the issue is, what are you doing with your portfolio to make sure that you don't have risk on a go-forward basis with the way FAPA has changed the rules of the road? Anybody who's ever seen me talk sees this slide all the time. Affixing allonges to the notes. It is the issue du jour that I am seeing in the industry, and that is borrowers saying you lack standing because the allonge is not affixed to the note. Anybody who's been in the industry for a while will know that back in 2014, sometime around there, maybe 14, 15, 16, standing was the issue du jour. And then the Court of Appeals said in Aurora versus Taylor that it's the holder of the note that has standing to foreclose, and that's true. But New York has a very archaic UCC. We have the first iteration of the Uniform Commercial Code, and under our iteration of the Uniform Commercial Code, the allonge must be, quote, so firmly affixed as to become a part thereof. And that has been interpreted to mean you got to have a staple and not a paper clip. Literally, there are cases out there where the parties walked into the courthouse with the note, the allonge is not stapled, and the judge dismisses the foreclosure suit. Now, what does this matter when it comes to FAPA? And I put this first case on this slide because I want to also demonstrate another point. FAPA affects commercial mortgages too. And the commercial market's in an absolute state of disarray right now. So if you're foreclosing on commercial loans, this matters to you too. And you see here, we have this REO opportunity case where they go all the way through trial and they come out with a reversal from the appellate division saying, you actually, the allonge is not affixed to the note, and therefore you may not have standing to bring this suit. So it gets reversed back down to the lower court. But that's 4.5 years after the loan matured. Now, what happens if they go to trial, they proceed to trial on that issue? If the allonge isn't affixed, they're going to lose at trial. Now, they lose at trial, it's 6 years, they're done. That's a $2 million mortgage out the window if they don't properly proceed in that suit with caution. I don't know what the parties did. I don't represent the parties there, but it highlights the issue. And it's an issue for the consumer market. It's an issue for the commercial market. You got to identify when you accelerated the loan. You got to make sure that when you're putting your loan into foreclosure, your allonge is affixed to the note. If it's not affixed to the note, I mean this with all sincerity, go back to your offices and start a process to address this right now. I've seen a million collateral files. Many of them come out of Calabasas, California, and the allonge is not always affixed to the note. So please do that. If you're transferring paper, you're maybe a correspondent lender, when you transfer the paper, affix the allonge to the note. And in that way, you can make sure that the purchaser has the staple. Now, very, very possible they may say they don't want that because it inhibits the copying process, but you're giving them a better ownership of the instrument than they'll get if it's not affixed. That's a problem. Next slide, please, Jody. Another thing you've got to be aware of is borrowers litigating all the way to trial, right? So sometimes borrowers can create issues on summary judgment, and you go to trial instead of summary judgment, which is their right to raise these issues, and you end up coming out of trial with sometimes with a loss. And now with FAPA, if you come out with certain losses, you're not going to be able to recommence. You're done. The whole asset is lost irrevocably. And an example of this is this Nadamelzi case, 21st Mortgage versus Nadamelzi. They commenced their foreclosure suit in November of 14. July of 19, they go to trial, and it results in a favorable outcome. But foreclosure counsel never put in evidence about compliance with RPAPL 1303. That's the steps, different colored notice on top of the summons for those people out there who are familiar with the filing of First Legal. And the trial court said, well, that wasn't a big deal because the process server's affidavit established that. But then the appellate court said, nope, reverse the trial judgment and sent it back down. But it has already been 6 years since they accelerated, and the loan's now time barred. Now, we're trying to make a precision argument as to why it's not. But the moral of the story is if the borrower litigates all the way to trial, a small foot fault, not putting in a blue color of the notice to tenants in foreclosure or notice to homeowners in foreclosure, that's enough to render the entire mortgage unenforceable forever. That's a huge consequence for a small foot fault. So those cases, I'm not managing servicing departments, but I'd say you want to escalate that, make sure it's being monitored properly by your in-house legal, so that when you come out of a trial or you come out of, you actually, if you have an enforceable note, it stays that way, your enforceable mortgage. The next piece of that is the business records issues. I was recently in the appellate division 2nd department, and they were talking about how do you prove the calculation of the amount due on the debt. And one of the questions that I was asked was whether or not the printout, the screenshot of the servicer's platform was sufficient business record to prove the calculation of the debt. And we don't know that it is or it isn't. They haven't ruled on it, but I have a bad feeling about the way that's going, because when you think of the printout just shows an accumulation of the interest that's back due. It doesn't show the actual calculation of it. So I can see how the 2nd department might come back and say just a printout of the screenshot is not enough to prove the interest that's due. You actually have to physically show the calculation. We've developed some workarounds for our clients on that, how we can show that. But again, with FAPA, and the reason this matters is because all of this prolongs your suit. And when it prolongs your suit, you only got 6 years. Just like I think it's coming down to what Eminem told us, you've only got one shot. So you don't miss the opportunity. You've got to make sure that you've got flawless execution by your foreclosure counsel. So you want to have that being monitored by your in-house legal very closely. Next slide, please, Jody. There was one, yeah, there we go. And then finally, if you are an asset purchaser buying mortgages on the secondary market, I know that the purchase and sale agreements, usually there's a very small due diligence period, and it's a very small world of documents that you're entitled to get. But you got to do some due diligence into whether or not the loan was for a pending foreclosure action, if it's an NPL, whether that suit is a good suit, it's a viable suit. And then you've also got to look into whether or not the loan has been accelerated previously, because acceleration can come about by notice. And actually, if you're in the commercial space, it often does come about by notice. The acceleration is often done in the notice of default to the commercial borrower. So you want to know when that date is, because you want to know when the 6 years may come to render that particular asset unenforceable. I've worked with some purchasers buying some NPLs on the secondary market, negotiating the universe of documents that they're entitled to review as part of their review process. It results sometimes in a repricing of the loan in the pool. But you really need to look at it because under, particularly if the loan's already in foreclosure, under the new CPLR, that should be 205, not 2025. 205-A, as Steve was talking about in the Fox case, really only the original plaintiff can recommence. So you don't acquire a right to recommence for a foot fault, and you're going to pay a large price for your transferor's mistakes. And I put on here to remember GMAC, One West, Ditech, Sterling National, right? These are all institutions that hit some financial difficulty. People went out and purchased their assets on the secondary market, and that created a lot of issues. I hope overall it was more beneficial than it was in creating losses, but FAPA certainly, its intent is to make those loans unenforceable. So that's what you got to do if you're buying on the secondary market. And now Steve's going to talk about some other issues.
Yep, Jody, let's move on to the new legislation.
Jody, you're muted.
Okay, same. We don't have any questions, but actually I have a question. So if that's okay. So when we talk about the business records and showing those calculations, right? Like, is your advice, Adam, that servicers should start to show those calculations or wait? Like, I'm just curious if you've got some suggestions there.
Yeah, I think showing the full history with the interest calculation, like an amortization schedule, is the way to go if it can be produced. I think having a screenshot from the servicing platform, just saying there's, 55,000 of accrued interest is going to be insufficient on a go-forward basis. The judge was very intent in their questions. I know it's being challenged everywhere, but showing those calculations at the rate, which can be difficult because when you buy on the secondary market, sometimes you'll have interest rates that fluctuate, right? You've got, it could be tied to LIBOR. LIBOR no longer exists. I've seen NEGAM mortgages, right? I don't know if those products are still out there, but if you've got a negative amortization mortgage, it NEGAMs for a year because it self-pays. And then you've got to show those calculations though.
Yep. Okay. And then my last comment is, staplers for everybody, right? Like I never realized how important a stapler was or stapling a couple of documents. So, okay, very good. Thank you. All right. We will go to our next slide, Stephen.
Thanks, Jody. This is turning to problematic legislation that affects mortgage servicing. Pending bills, companion bills in the Senate, it's Senate 6971 and then Assembly Bill 7546. Adam's going to get into the details as far as the specifics. I'm just going to give a quick overview and then why we were compelled to act. The legislation creates a number of new statutes, including amendments to RPAPL 1302, 1321, CPLR 213, CPLR 203, among other statutes, which are problematic. The organization identified right away that this was going to be a problematic piece of legislation by two problematic legislators in terms of addressing mortgage legislation. So the organization quickly acted, sent a memorandum in opposition to address the proposed amendments to the RPAPL and the CPLR. The legislation intended primarily to address subordinate mortgages and notes, but as Adam will get into greater detail, it not only affects subordinate mortgages in a very dramatic way, it also affects enforcement of senior lien notes and mortgages prospectively in some sense. There's some retroactivity inherent to the legislation in terms of retroactively impacting servicers in some ways, but unlike FAPA, it doesn't include the retroactivity clause that expressly intends to affect pending cases. But here's a key content of our memorandum in opposition that we submitted a few weeks ago. And like I mentioned, it's supposedly intended to address concerns the legislature had regarding subordinate mortgages. They call them zombie mortgages. Typically, the 80-20 type loans where the junior lien was not enforced for a while. The junior lien may have been in default, but it wasn't enforced by the lien holder for a number of years. Therefore, it was never accelerated. So the loan remained in the land records. The mortgage lien remained in the land records, but there was no action taken despite it being in default for a number of years. And then due to rising equities in New York, property values, that is, some default note purchasers were acquiring the second liens and ultimately seeking to enforce them. So the legislature in the sponsored materials claimed that the legislation was intended to curb that practice. However, it goes far beyond that as usual. It's another omnibus type legislation involving mortgage foreclosures. And Adam can get into that a little further, but obviously the fact that we acted so quickly, like I said, it's in the Senate, in readings in the Senate, Judiciary Committee, in the Assembly, potential to still move, but it was the most problematic bill we identified in terms of mortgage servicing that's currently pending before the legislature. And we will obviously keep all the members and attendees updated on the status of it and our opposition efforts. But Adam can deliver the great news as to what this bill includes and the specific amendments. I think, again, about 10 different amendments that we'd be dealing with trying to comply with.
Real quick, and before Adam does it, I just want to share, right? So the New York MBA, because we're so concerned about this legislation, right? Obviously, we've prepared the memorandum in opposition, as you have pointed out, Stephen. But we have also, in conjunction with our lobbyist, we have met with Assemblymember Levine's office. We've had a second meeting with Levine's office, and we've met with the Central Staff for Judiciary Committee as recently as last week. Just to address our concerns, and just making sure that our certainly our voices are being heard in Albany and sharing, all of our concerns and how this just negatively impacts our industry. So thanks for that. Go ahead, Adam.
Thanks, Jody. And like Stephen was saying, this bill ostensibly is to address subordinate mortgages, but when you parse the language of it, it actually affects first mortgages too. So it's not just subordinate mortgages. And I understand from those who have met with the various members of the legislature that this was brought to their attention, and it got no response. Initially, the thought was perhaps it was an oversight and inartfully drafted, but they have not amended the text. So this is the bill that we have. So the first provisions that affect first mortgages require that when a mortgage, a home loan is the term of art that's used, is put into foreclosure, the plaintiff must have a, quote, complete schedule of all transactions credited or debited to the mortgage loan account from origination to inception, to enforcement. For those purchasing mortgages on the secondary market, that doesn't always come with that full complete schedule of all transactions credit. And this includes the escrow account. And for those who may be servicing their own portfolio, why this matters to you is because if you want to ensure that your assets remain saleable and you can generate liquidity by selling, you better be keeping that complete schedule of all the transactions to include in the sale of that loan. The failure to have this complete schedule of the transactions is a defense to the foreclosure suit, meaning if you don't have it, you can't enforce the mortgage. It's pretty draconian. It applies to first mortgages. And the reason that Steve was saying before is that it has retroactive impact is because this applies to all mortgages, whether or not they were bought and sold 5 years ago. So it's just when it's put into foreclosure. So if you're looking in your portfolios now, you have some non-performing loans, and those loans are not originated and serviced by you, you're going to need to look and see if you have that complete schedule of all transactions. The next piece that affects also first mortgages is that a foreclosure plaintiff who claims standing through note possession, and that's what we were discussing when I was talking about affixing allonges. So you actually have physical possession of the original promissory note. They have to maintain or be in possession of a custodial file documenting possession, including a, quote, chronological listing of all prior entities that physically possess the note. In my humble legal opinion, that flips the Uniform Commercial Code on its head, because the purpose of the Uniform Commercial Code was to encourage the free flow of commercial paper, which is why an endorsed promissory note should be transferable just by transfer of possession alone without having to keep this log. But here is where we are. They didn't care about my opinion. So this in essence means that if you are servicing a note, a note and mortgage, and you need to put it in foreclosure, you better get that complete custodial file showing a chronological listing of everybody who's held that note from the inception to date, or else the borrower is going to have a defense to your foreclosure action. For those who have portfolio loans that they originate and service on their own in-house platform, this may not be such a big deal, particularly for servicers who are servicing for investors who purchased these loans on the secondary market. This is going to be problematic for you. Oftentimes, the custodian is appointed in the original transfer when the mortgage is securitized, and the custodian may not change. And in those circumstances, that may be it may be okay, but oftentimes the custodians do change. And where that happens, you need to have that chronological listing from origination to inception of everybody that held it, or else the borrower is going to have a defense to the foreclosure suit. The last piece that also affects first mortgages is that the legislature has now created the statute of limitations a non-waivable defense. We saw this happen a while back with standing becoming a non-waivable defense. And for those non-lawyers in the audience, in essence, whether it's waivable means whether or not it's been asserted in the pleading. And there have been several cases where perhaps the loan is barred by the statute of limitations, but the borrower didn't raise that issue. Borrower may not want to raise that issue, but sometimes they don't raise that issue, and then it becomes a waivable defense. Well, no more. Just because they didn't raise it doesn't mean they can't raise it at trial. Just because it's not in the pleadings doesn't mean they can't rely on it as a reason to prevail in the foreclosure suit. So it really takes the statute of limitations out of the realm of being a defense and elevates it to being a party or cause of action almost, because these changes really upend the law in the state of New York. And it's really created a whole new regime for foreclosure. So if you have portfolios that are seemingly going in a negative direction, you're really going to have to up your business records and keeping track of things like the schedule of payments, getting the prior schedules from prior servicers, having that chronological listing of everybody who's held the note, and ensuring that the loan has never been accelerated before you file first legal. Now, the impacts on the second mortgages, which is what this was intended to affect, they're even more draconian. In terms of the second mortgages, what the legislation speaks to is when a home loan is a subordinate loan and it is purchased after it's been in default. Those are the requirements. And home loan, by the way, is 1 to 4 family, borrower occupied, the traditional consumer type of a mortgage, a residential mortgage. So this legislation does not impact the commercial market, if you're wondering. But in terms of the home loan, if it's a subordinate loan and it's purchased while it's in default, you have to allege in your complaint the date you purchased it and the price you paid for it. And if you bought it in a portfolio of loans, you got to use a ratio. You take the whole unpaid principal balance of the pool, and you figure out the proportion that this unpaid principal balance is to the pool, and then you multiply that by the purchase price of the pool, and that comes your what you paid for the loan. You've got to allege that in the complaint. Now, why do you have to allege that in the complaint? Because you're not allowed to collect any more than what you paid for it if you buy a second mortgage in default on the secondary market. That is why I say this is extraordinarily draconian. Essentially, if you purchase a second mortgage on the secondary market, let's say for $20,000, and that mortgage was a $150,000 mortgage, I'm just making numbers up, you can only get $20,000 under this new legislation. Whether or not this is constitutionally proper remains to be seen. I'm sure there may be challenges. I've already spoken with some clients who do have pools of second mortgages who are extremely unhappy with this outcome. And then the next consequence is that the interest rate is the maximum allowable under Section 14-A of the banking law. That's essentially the usury rate, which is 16% in New York. But if you go and you dig down into the regulations, the actual rates vary by the unpaid principal balance. So you want to look into that. Don't just rely on the 16%, which for some second mortgages may be beneficial, but for others may be a cram down of the interest that you can charge. The next consequence is that those loans have a shorter statute of limitations. Remember, you're buying it in default. So you have 3 years from the date of purchase. Yes, you heard me right, and I read it twice. 3 years from the date of purchase, or 6 years from acceleration, whichever is lesser. So when you buy the loan, you got 3 years to foreclose it, or else you can't foreclose it again. And remember, that's an unwaivable defense now. So that's another extraordinarily draconian piece. And then the legislature has decided that demanding payment in excess of what they're allowing you to recover on that mortgage, which is only your purchase price, will constitute a failure to negotiate in good faith under CPLR 3408. 3408 is the foreclosure settlement conferencing statute, where the courts have decided that if you don't negotiate in good faith, they can issue certain sanctions against you, including monetary sanctions and tolling of interest. So we've really got a draconian impact on the second mortgage market. For those out there who are in awe, I'm a little bit in awe myself. I will tell you that there have been instances of private investors purchasing bad loans from certain lenders and having no records at all of what's owed on these loans, buying them for pennies on the dollar and foreclosing them as a means of wresting the property from the borrower, particularly in the current financial climate where the property is not underwater and the property actually is quite valuable, even with regard to the mortgage debt secured by it. And that's what the legislature is responding to here. It's probably a handful of sharks, and I won't name their names. I know I know their outfits, though I know their companies, and that's what they do. They buy this paper from some of the national banks, and sometimes they don't even get any documentation with it. And then they go out and bring foreclosure suits, and they have no records whatsoever. That's what the legislature is responding to, but it's an overreaction because it's really going to upend the second mortgage market in the opinion of some.
Okay, and I thank you, Adam. I mean, in awe is what you may say. I feel like ill. I feel sick over this, right? It's terrible, terrible legislation. And I do want to reiterate, like New York MBA, and in conjunction with our lobbyists, like we are meeting with the stakeholders in Albany. We have taken this up to the highest level that we can take this with, meeting with the Assembly for Policy and Legislative Affairs. Like, we are not quitting, we are not going away. We will fight this with everything that we have. So thank you for that. And gosh, Lord help us. Okay, we are next up to additional New York legislation that we are monitoring from a heavy focus of servicing and our legislative committee. So with that being said, I will hand it over to Adela Martinez.
Hi there. So I am going to talk about 7 additional key New York legislative bills that New York MBA is monitoring on behalf of its members, in addition to what we've already heard about from Steve and Adam. But first, if you want to monitor the bills on your own and review key memos, you can go to a website link for quick reviews of pending legislation and current status at newyorkassembly.gov/LEG, and I'll drop it in the chat later, or we'll make sure it's in the presentation. Okay. As you can see on the next few slides, we've listed the current bills pending, what the bill number is, the speakers, title, summary, and our notes, and what New York MBA's position is on these. So important bills to note. The first one listed is bill number A01799, and you can look it up by either one of these numbers. It's an act to amend the banking law, and in relation to prohibiting financial institutions from charging a fee for periodic paper statements if they're required for application for public assistance. And our position, or New York MBA's position, is just to continue to monitor. It's already passed Assembly, referred to Senate banks. And I'm not going to go through every single one. I know that we're quickly running out of time. But so next is, let's see, we have AO 2739, which is relating to payoffs, making sure that payments are applied timely, making sure that we're avoiding returning or destroying payments, and executing and recording satisfactions of mortgages within specific time frames. So that we're looking at, we're monitoring it, and its amendments could be necessary. I am going to, so the next one is for disaster victims of local or major disasters. And it's really a tax relief act, and it has been signed by the governor in February 2025. Let's see. The next one is really, the summary is, it's more geared towards small property owners, those that are defined as owning 20 units or less, and they're entitled to free legal service if they can demonstrate 20% or greater loss in rent payments in a current year. So that's in the Assembly judiciary, and we're monitoring, and we support this. Next slide. Okay. So this next page, we have three key bills that are amending real property actions and preceding law, and it's really surrounding the increase of penalties it's surrounding the compliance with maintenance and reporting of vacant and abandoned properties. And it is our notes are, it's already passed the Senate, it's referred to Assembly, judiciary, and we feel it's problematic and sweeping overcorrection to gaps in zombie law language. And the bill is focused on penalizing the mortgage industry for DFS failure to effectively enforce the zombie laws. And what they're proposing is to increase daily penalties from 500 to 1,000 daily. And New York MBA's position is to oppose it. The next two are also relating to real property actions and preceding laws. They're both in Assembly judiciary. I know I'm running out of time. So this again is relating to the civil penalties and allowing municipalities to prosecute and prosecute violations and retain civil penalties. The last one, again, is relating to DFS to seek civil penalties for violations of the duty to maintain a foreclosed property. So that's already passed the Senate, and it's been referred to Assembly judiciary, and we oppose that one. So I think that wraps that up.
Thanks, Adela. Like, I
Sure.
want to add that on Monday, earlier this week, the New York MBA, myself, Chip, and our lobbyists, we had a call with Romero's office, right, to kind of explain our position with respect to these bills and this proposed legislation on this last slide. I mean, first and foremost, we are in agreement that properties need to be protected and preserved 100%. We're not challenging that, and that we want to protect and preserve communities. We 100% want to do that as well. But, you know, we did a study probably back in 2018, and a lot of what they were finding is these properties not being maintained were not mortgaged properties. So, you know, very unfortunately, the servicers, the banks, originators, you know, we're the ones we're kind of getting the black eye for these properties that are not in the best condition. But the truth of the matter is they don't even have a mortgage. But I digress. We told them that we were in 100% agreement that maintaining properties, protecting communities is first and most important. Like, and again, you know, our reputations are on the line if we're not doing that. So we suggested to consider, you know, having an in-person meeting, partner with them to potentially create like a task force. So, but that, you know, that is just what the New York MBA does. Like, we want to be collaborative. We want to be a part of the solution. We want to partner, but we also don't want to, you know, continuously being beat up. At the end of the day, our members, servicers, originators, like we want to help the consumer. We are here to help the consumer and put them in a home and be, you know, a very good partner to them. So anyways, just a little bit more background on some of this legislation. Our last piece of legislation that New York MBA has been absolutely instrumental in is the legislation around manufactured title conversion to real property. And this legislation has been out there for, I don't know, I think anywhere from 8 to 10 years. And it was not getting any real traction. So New York MBA, we were monitoring it. We were having conversations. Long story short, we kept on pursuing our conversations. We have it very much back on track. We got fingers crossed that this is going to pass this year. And this is so important for so many reasons because, you know, being able to have that manufactured conversion to real property, you know, allows and would interest more people in doing manufactured housing in New York State, which is a major solution to affordable housing. And not only that, but it is a great avenue for the homeowner because if they can convert their manufactured, you know, documents, legal docs to real property, they're going to have better interest rates. So it is an absolute win-win for everybody. But New York MBA has been instrumental in getting this to the forefront once again, bringing all stakeholders from both Assembly and Senate to the table to have meaningful conversations. And I'll just say, if this passes, thank you, New York MBA, for all your incredible efforts and all the work that they've done. So, you know, this is the end of the webinar. Just a couple things. Today's webinar will in fact be on our YouTube channel, so feel free to check that out. Like and follow the New York MBA. Am I saying all of your stuff, Elizabeth? So okay, my apologies. I do though want to, you know, just take a minute to thank our panelists. Off the charts, best in class. We are so honored that not only do they take their time to be panelists to help us out, get the message out, but the fact that they're New York MBA members, they're always willing to help us. They're digging in, helping with amicuses, helping us with letters of opposition and memorandums. And we're just so incredibly thankful. So back to you, Elizabeth.
Just, and I want to thank everybody for attending today. And yes, a very special thank you to you, Jody, and the esteemed panel for just providing a lot of knowledge and insight into major legislative issues that are affecting servicing. And thank you very much, guys. Have a great day, everybody.